Hi, this is Brad Green with Probate Solutions Group and Green Realty, and today I'm joined by probate and trust attorney Owen Rassman.
Thank you, Brad. Appreciate it.
Let's if we could first just start off just a little bit about you and your business.
Sure.
Have any specialties?
Yeah, perfect. Owen Rassman. I'm a trust and estates attorney. Means estate planning, trust administration, and probate. They're in my world, they're all very much related. Um, we help people plan for death, plan for incapacity, and help families that are dealing with a death or incapacity, collect assets and take care of loved ones and settle loved ones' estates and affairs and things like that.
Right. And you've been doing this for how long?
I just started my 20th year as a lawyer.
Wow.
Um, And I've been doing this full time for 15 years. Started a firm in 2010, focusing on trust and estates.
Got it. And you're in San Diego, correct?
North County, Carlsbad, yeah, San Diego County. Yep.
So how do you get most of your clients, Owen?
It's changed over time, to be honest with you. When I first started, it was friends and family and doing my best to network with other professionals, other attorneys, CPAs, real estate agents. That's how I started. And I've been fortunate that that's transitioned to just a nice book of business. Now I get referrals from all those contacts I made over the years, and then referrals from all the clients I've helped over the years. And then now with social media, I have a partner who handles kind of the social media end of things. I'm not super tech savvy. I spend most of my time, client facing, and my partner kind of handles the social media side of things. But been pretty fortunate just to have a nice book of business, and that just somehow or another keeps sending business my way. So it's nice.
Nice. And when a client works with you, what do they get?
Depends on what type of client. So, I have my estate planning clients. That's me and a client, whether it's a single individual or a husband and wife. That's us planning for a future event, whether that future event is incapacity or death. It's a very friendly, relatively smooth process. I document their wishes essentially. We do that through a collection of documents. We call this an estate plan. It's a collection of documents. It's a trust, wills, powers of attorney, healthcare directives, things like that. We do estate planning. So this is estate planning. We do that on a flat fee basis. I'll quote clients a fee and I stick to it. I don't send them surprise invoices. I don't keep track of emails, phone call. I mean, when I say I don't keep track, I don't charge zero point 0.1 hours to get an email. I don't charge hourly to answer questions. I do it on a flat fee, or we do it on a flat fee basis, and the price is what it is. So that gives clients kind of the confidence they need to ask questions and not be worried about getting a surprise invoice from me. So that's estate planning. Trust administration is a slightly different part of my practice. That's where we're helping, usually it's a family member, but we're helping a family member settle a loved one's affairs, a loved one's estates because they've either passed away or they've become incapacitated.
Right.
We do that on an hourly rate. And then finally, probate. I have a feeling you're going to ask me some questions about probate. Probate is done on a statutory basis, meaning probate attorneys get paid a percentage of the fair market value of the assets that are subject to probate. So that's not flat fee, it's not hourly, it's based on a percentage.
Okay. And I understand California, there's a sliding scale, correct? That
Uh,
attorneys use.
that's correct, yeah.
Okay. So understanding a little bit more about probate, what is probate?
Probate is how much time do we have? Probate is it's a court process, just to kind of keep it high level. It's a very long, 9 or 12 months minimum court process, which involves attorneys, judges, courts, filing fees, publication in the newspaper. It's this very long process. And it's a very expensive process because there's an attorney getting paid a statutory fee based on that percentage we mentioned a minute ago. There's a personal representative getting paid a statutory fee based on that same percentage. A personal representative, another name for that is an executor
Mm.
or an administrator. It's all more or less the same. Um, so yeah, high level, it's a very long and very expensive court process.
Got it. So are there times where probate's not necessary?
Yeah, yeah. So avoiding probate, I always tell clients, look, if you don't know what probate is, from now on, when you hear the word probate, just think bad. Probate bad. Avoiding probate is one of the big goals of estate planning in California. There's clearly other goals, but avoiding probate is one of the biggest goals. And yeah, to your question, there's a few ways to avoid probate. Number one, if you create a trust, you being the client, if a client creates a trust and transfers their assets to the trust, those assets are not going to be subject to probate because assets owned by a trust are not subject to probate. So that's one way to avoid probate.
Okay.
Another way to avoid probate, some assets we don't transfer to the trust. A good example would be like a retirement account, like a 401k or an IRA. Generally speaking, there's exceptions to every rule, of course, but generally speaking, we don't put IRAs or 401ks in a trust. They're not owned by the trust. A client's home, absolutely. That
Mhm.
is very often owned by a trust. A retirement account, on the other hand, we don't, generally speaking, transfer those to the trust. The way you avoid probate for things like retirement accounts, name beneficiaries. Most custodians, Charles Schwab, Morgan Stanley, Merrill Lynch,
Mhm.
Fidelity, Bank of America, whoever the custodian might be, most custodians have forms you can fill out to designate a beneficiary. And assets that have a beneficiary designated on death, as long as that beneficiary is alive, are generally speaking not subject to probate. So assets that name beneficiaries, that's a second way to avoid probate. I could give you three or four or five additional ways to avoid probate, but those are the two big ones.
Got it.
Yeah.
Um, a lot of people feel that if they have a will, then they don't need a living trust. Can you talk about that a little bit?
I would say for a minority of people, that might be true. Not everybody needs a trust. It kind of depends on what your assets are. Um, the general rule is wills do not avoid probate. I try to make sure my clients understand that. I repeat it countless times over the course of my representation of a client. General rule, wills don't avoid probate. There's exceptions to that rule. If we're talking about small value assets, a small bank account, for example, okay, that's not entirely true, but the general rule, wills don't avoid probate. Um, Assets in a trust avoid probate. Assets that name a beneficiary, as long as that beneficiary is alive, those avoid probate. But wills, the general rule, do not avoid probate. So in an estate plan, if you're, looking to get an estate plan done, for the vast majority of us, we have a will and a trust. There's a reason to have both. Um, at risk of being redundant, wills by themselves, generally speaking, don't avoid probate.
And if a descendant passes without a will, but they
Yeah.
have a living trust.
So if if on death an asset is owned by the deceased person's trust, it doesn't matter if they have a will or not, because if an asset's in a trust on death, the trust says who inherits that asset. No probate, because assets in a trust are not subject to probate. So if someone dies without a will, but they have a trust, which would be unusual because usually if you have a trust, you also have a will. But to address your hypothetical, if someone dies without a will, but they have a trust, and the trust owns something like a home,
Mhm.
doesn't matter that the person didn't die without a will because the trust says who inherits whatever the trust owns, like a home. If someone dies without a will and does not have a trust, and if that person owns assets, well, remember before we talked about beneficiary designations?
Right.
Someone could die without a will, without a trust, but if they've got beneficiaries designated on that 401k or that IRA, as long as that beneficiary is alive, there won't be a probate, and it doesn't matter that they died without a will. Where the problem is, if someone dies without a will and they own something that isn't in a trust and doesn't name a beneficiary on it, the general rule is, probate, number one. Again, exceptions to that rule, but the general rule is okay, that asset's going to be subject to probate. And then it comes down to what California law says as to who inherits. So, creating a will and creating a trust, this is your opportunity to say who inherits from you. You put it in writing. You do it through a combination of a will and the trust. That's your opportunity to say who inherits from you. And if you don't take that opportunity, you don't create a will, you don't create a trust, and you pass away, California law says who inherits. And again, we're talking about California residents, right?
Right.
Residents of other states, their state is going to govern who inherits. But California law says if you're a California resident, you pass away without a will, your assets are going to get distributed to, and then California has kind of this waterfall, so to speak, of who inherits. Generally speaking, it's a combination of a spouse and descendants, children, grandchildren, great-grandchildren. It's firstly a combination of the spouse and descendants. And if there's no spouse or no descendants, then it's your parents. And if you don't have parents, then it's your siblings. And if you don't have siblings, then it's your nieces and nephews, and then uncles and aunts, and so on and so on and so on. California sets forth who inherits if you die without a will, for assets that aren't in a trust and do not independently name a beneficiary.
Okay, great. Okay, so I wanted to just shift gears a little bit and talk about the probate process and how long does an average estate take to settle once probate's opened?
Mhm. Time-wise, it's a minimum of 9 months. Every county in California is, going to be different. Some counties are, the court systems are more backlogged than others, so it's somewhat county specific. But just as a general rule, 9 months minimum. The reason for that is, um, from the day the executor or the administrator, from the day they file the petition for probate, it's going to take, depending on the county, 45 days, 60 days, 90 days to get in front of a judge. So you're already, let's just call it 2 months before, at a minimum, before you're in front of a judge. Then once you're in front of and you need to get in front of a judge, because the judge is going to be the one that appoints somebody as the executor or as the administrator. Again, those terms are somewhat interchangeable. There's a slight difference, but
Is the administrator going to be there in front of the judge, or is just the attorney?
usually it's just the attorney. Thank you. Usually it's just the attorney that appears on behalf of the executor/administrator. But yeah, you need a judge to appoint somebody, and that's a minimum of, probably 2 months before you're in front of a judge. Then from the day that someone is appointed as the administrator of the probate or the executor of the probate, there's a 4-month creditor claim window. Creditors have 4 months from the date an administrator or an executor is granted their authority to file a creditor claim. So there's a 4-month statutory window for creditors to file a creditor claim. And that marks the end of that 4-month period, marks the absolute earliest that somebody can petition the court for what we call final distribution, because you can't distribute, meaning the executor/administrator, cannot distribute assets subject to probate to the beneficiaries of the probate without a judge approving it. So the end of that 4-month window for creditors to file their creditor claim is the absolute earliest that the executor/administrator can file that petition for final distribution. And then you're back, and then it's a waiting game again. It's another 2, 3, 4, 5 months, depending on the county and how backlogged they are. It's another X number of months before you're back in front of a judge to get the authority to distribute assets to the beneficiaries. So if you just count up all those months I just mentioned, 2 months to get in front of a judge on the petition, 4-month creditor claim window, and then another 2, 3, 4, 5 months to get in front of the judge on the distribution, you're already at 8, 9 months minimum. And that is assuming everything else in the probate goes smoothly. And I could give you examples of why that may not be the case and is often not the case.
Got it. Got it. Um, and you talked a little bit about their scheduled fees by California probate. Can you go a little
Yeah,
more detail on how the fees work?
sure. Two people are entitled to get paid in the probate: the executor slash administrator and his or her attorney. And they both get paid, each of them, 4% of the first $100,000 of value, 3% of the next 100,000 of value, 2% of the next 800,000 of value, and then 1% of everything above a million. Um, and they're both entitled to get those percentages. So if you want to put it into real terms, it's not uncommon for someone in coastal California, at least, to die owning a home. Let's say the home is worth 800,000. It's not uncommon to have an $800,000 home. It doesn't matter if there's debt on the home. There might be $799,000 of a mortgage, but for purposes of these fees, it's irrelevant that there's a mortgage because the fees are based on the fair market value. So, taking an $800,000 home through probate is going to cost 4% of the first 100,000, so that's 4 grand.
Mhm.
3% of the next 100,000, so that's an additional 3 grand. And then 2% of the next 600,000, that's going to get you to that $800,000 number. 2% of that next 600 grand is 12 grand. So you add those up. 4 plus 3 plus 12 is 19,000. So to bring an $800,000 fair market value home through this probate process is going to cost $19,000 of fees to the executor slash administrator, plus $19,000 of fees to his or her attorney. I'm a lawyer. I'm not a math guy, but I think that's
Right.
38 grand. In addition, there's gonna be two, three, $4,000 of filing fees. In addition, there's going to be approximately $1,000 paid to somebody we call a probate referee. This is the person that gives the home the appraisal, the value. There's a publication requirement. So you're looking at over $40,000 for an $800,000 home. And of course, there might be other assets as well.
Right.
Maybe there's bank accounts, brokerage accounts. There might be other assets in the probate as well,
And
increasing that.
you and the attorney and the administrator gets a piece of everything, not just that.
Yeah, that's correct. Each of those parties are entitled. I'm going to emphasize entitled. I'll tell you why in just a second, but each of those parties are entitled to get paid that statutory fee based on those percentages. The reason I'm emphasizing the word entitled, um, it's it's not uncommon for an executor or an administrator to refuse to take the fee. In a very close family situation, every dollar that the executor administrator takes as a fee is a dollar less that's going to the beneficiaries. So sometimes you have someone that says, look, I don't want to take the fee because that means my brother, my sister, they're not getting money as a beneficiary. Um, in addition, the money that the executor slash administrator takes as a fee, it's taxable income. So it's not really a dollar, it's a dollar minus the tax that the income tax that the person has to pay on that money. So it's taxable income. So it's not uncommon for the executor or administrator to say, I don't want the fee. It's also not uncommon for the executor administrator to say, I absolutely want the fee.
Well, and it is a lot of work, as
And it is a lot of work, right? Thank you. I mean, it's a lot of work. So there are people that say, look, I've put in 9, 10, 12 months of time on this thing. I feel it's only fair that I get paid, for the work I've done. What I will tell you is the attorney is always going to take the fee. I know, shocker. I know everybody listening to this is surprised to hear that. The attorney, of course, is going to take the fee. I mean, this is what the attorney does for their career. Um, so the attorney is going to take the fee. And of course, you can't avoid those other, court filing fees and things like that.
right. And you mentioned if a house is worth 800,000 and there's no equity in it, they owe 790 on it.
Yeah.
Uh, what happens if they don't have the money?
Well, it's a good question. Hopefully they've got an attorney that is looking at that before the petition for probate gets filed. There are instances where petitions get filed for assets, and it turns out that there's no money to be distributed to the beneficiaries or no money to go to the attorney or the executor. That's probably, that's one hypothetical that you just mentioned. Hopefully you address that before the petition gets filed. Otherwise, there will be a lot of work done for no compensation to that personal representative and his or her attorney. So you gotta, there's obviously many factors to take into account before you rush to the court to go file that petition, and that's one of them.
Um, Probate mistakes. What are the most complicated states you have moved through probate?
Uh, Good question. I am working on a probate now. I rather than go back and think about prior probates, let me give you my most complicated current probate. Uh, an elderly woman passed away. She owned her home in Encinitas, California. You can guess what the value of that home is. Um, she had a will from 40 years ago, and we petitioned the court. And there's other assets besides the home, but in fact, there was a lot of other assets besides the home, including an LLC and a lot of stuff in the home. I mean, a lot of stuff in the home. We petitioned the court to get that 40 plus year old will admitted. In other words, get the court to say, yep, this is the document that's going to determine who inherits. And several months into the probate, another will surfaced. Um, and that new will had all sorts of cross outs and writings and additions that this deceased person made by hand to the will. So, and had different beneficiaries. It had a different person nominated as the executor. So here I am as the attorney representing the executor of the really old will when a newer will is found. And I mean, I don't think it's a surprise to say it turned into a big issue as to whether this new will was valid. What do you do about all those cross outs, additions, initials, etc.? And who has the authority to be the executor under that new will? Fortunately, on this particular case, I mean, this really could have turned into a very ugly, very prolonged litigation.
Mhm.
Fortunately, in this case, the majority of the beneficiaries between the two wills were the same, the majority, not all of them. And we were able just to work out a deal essentially outside of the court as to, who's going to inherit and who's going to inherit what. So we kind of did an out of court agreement amongst everybody to avoid litigation and got it resolved. But, you know, that was a that could have easily gone the other direction where beneficiaries were refusing uh to come to an agreement. And then next thing you know, now there's a very even a prolonged litigation within the probate. So that would be an example. It's an example of somebody doing their estate planning on their own without an attorney and not understanding the mess that they might be creating after they pass away. Now, of course, they're deceased, so it's not their problem,
Right.
but it is certainly their loved one's problem.
What are the biggest mistakes you see families making uh, during probate?
Arguing over immaterial things in the big scope of things, obviously when someone passes away, there's a lot of motion, there's finances and economics to consider. It's not uncommon when two people have equal priority to be the administrator. And it's not uncommon for those people that have equal priority to just fight. The most preliminary issue is who's going to be appointed by the court as the administrator. And the estate can't even get off the ground and running until there's somebody in charge, until there's an
Right.
administrator. So, yeah, I mean, I've seen cases where parties can't even agree as to who the administrator is, nor can they agree to neither one be the administrator and just instead nominate a neutral party, like a professional fiduciary, for example, um, just to get the probate started. So again, there's just a lot of emotion, when someone passes away, and parties that may have previously been very loving and friendly to each other. It's not uncommon for those relationships to sort of dissolve and things to go sideways.
Right. And that if a fiduciary was appointed, they'd be getting that same sliding scale, correct? So they'd be
That's
giving away quite a bit of their money.
that's true. Yep, that's true. If a professional fiduciary gets appointed, yeah, he or she, like the attorney, this is what they do for a career, so they're clearly going to charge for it. But I don't know that, in this particular hypothetical, uh, that's going to happen no matter what. Let me say it differently. In this particular hypothetical, where you've got two parties who clearly cannot agree, both fighting to become the administrator, even if one of them were to prevail and be appointed by the judge as the administrator, if there was truly that much of a fight to get appointed, you would expect that party to take the fee.
Right.
So regardless, there's going to be a fee. I would love it if I saw people just agree to not fight and just appoint a neutral fiduciary to get the ball rolling and the probate started. Again, I'm saying that as an outsider, as an attorney who doesn't have the emotional attachment that a son or a daughter who just lost a mom or a dad might have. So we come at it from different perspectives, of course. Um, but that's an example.
So probate best practices, what's the best advice you can give to family that's probating an estate?
If I'm giving advice to a client who is typically the person appointed as the administrator or as the executor, if that's the question, first and foremost, do not commingle assets. What that means is there's going to be the probate assets, maybe the decedent's home or the decedent's bank account. And then there's going to be my client's personal assets, his or her personal checking account, personal savings account. First and foremost, do not commingle those things. Probate assets need to stay in the probate, in a probate bank account, for example, and should not be commingled with someone's personal assets. I mean, that is probate 101. Do not commingle. Do not take assets out of the probate and give them to the beneficiaries without a judge approving it. These are assets that are part of the estate and cannot be given to beneficiaries without court approval. Keep impeccable records. If an administrator is paying creditors, well, always get your attorney's advice before you pay those creditors. But if the administrator is incurring expenses, whether it's paying a creditor, paying taxes, paying utilities for the decedent's home, um, whatever the case may be, keep impeccable records, keep receipts, keep track of every penny that goes out for an expense and every penny that comes in as an asset. So, really good record keeping. Um, and always ask your attorney before you make any material decisions. To keep it in layman's terms, I've often said to clients, again, there's always exceptions to every rule, but I've often said to clients, before you make a decision, whatever that decision might be, whether it's to pay a creditor or pay utility bill, um, before you make any to sell an asset, sell the home or liquidate a stock or whatever the case may be, before you make any decisions as the administrator, fundamentally just ask yourself, if I do what I'm about to do, sell the home, liquidate a stock, pay a creditor, am I benefiting the beneficiaries of this estate? Am I benefiting them? Or am I just benefiting myself? And depending on the answer to that question, that's a pretty good indication as to whether the person should make that decision or not. That's a very high level rule. Of course, you should always run the decision by your attorney, but that's a somewhat simplistic way of looking at things. And it helps, I think.
You talked about paying off their debts. Where does this money come from to
Well,
pay?
yeah, I mean, look, the fact that somebody's in probate, or technically speaking, the fact that there's an estate subject to probate would imply that there's assets there because there's exceptions to this rule, but usually if there's a probate going on, that means there's assets. There was a home, the deceased person owned a home or owned a bank account, didn't have those things owned by their trust, didn't have beneficiaries designated on those things with the bank or the custodian of the IRA or whatever the case may be. If there's a probate, it implies there's assets, and if there's assets, there's money there to pay the expenses of administration. Now, maybe there's not liquidity there. Maybe on day one, the only thing there that existed was a home that hasn't yet been sold. And so maybe there's no liquidity there to pay those expenses, but more often than not, there will be liquidity when an asset sells, whether it's the home selling or stock liquidating. And so sooner or later, in a majority of the time, there's assets there to pay it.
So does the administrator or executor, do they have to oftentimes come up, pay these bills out of their own pocket and then get reimbursed later on?
Have to? No. Um, Often do they? Yes. Uh, for example, most probate attorneys will ask for a retainer. And the retainer can only be used for out-of-pocket expenses. In San Diego County, it's approximately $460 to file the petition. This is a fee that gets paid to the court. So I will often ask clients, look, advance me just enough money to cover my out-of-pocket expenses, the filing fee to file this petition, or the $150 it's going to cost to publish in a newspaper, or this or that. So it's not uncommon for the probate attorney to ask for a retainer to cover out-of-pocket costs. As a side note, the attorney cannot ask for a retainer to cover their fees. The statutory fee we talked about earlier, that's not allowed. Okay. But we can ask for a retainer just for out-of-pocket expenses. Um, and it's not uncommon for the person that's seeking appointment to be the administrator or the executor to personally advance that money to the attorney, and then for that person to get reimbursed later once there's liquidity within the estate. So from a legal point of view, does somebody have to come out of pocket with their personal assets? No, they don't have to. But from a practical point of view, it's not uncommon for that person to personally advance some money and then to get reimbursed later.
Okay. Well, hey, Owen, I truly appreciate the time you spent. Anything before we leave you wanted to add?
Uh, just get your estate planning done. I mean, probate bad. I think I said it earlier, you can avoid you as a potential client, as a homeowner, as someone who owns bank accounts or brokerage accounts or retirement accounts. For those of you that have, young children, you know, just avoid this whole probate process. Go work with an estate planning attorney. Yeah, of course, you're going to have to pay the estate planning attorney to get an estate plan done. I assure you, it's going to be a lot cheaper, a lot simpler than an actual probate would be. So, consider
Typical living trust is going to cost how much?
it depends on the attorney. The more experienced an attorney, typically the more they charge. I would say on the low end, I'm just going to talk about San Diego County for a minute. I'm sure you can find attorneys on the low end for $1,000, $1,500, $2,000 on the low end for relatively straightforward estate planning. It's also not uncommon to find attorneys that have a lot of experience and knowledge to be charging, $3,000, $4,000, $5,000. it varies greatly, but there's certainly some attorneys have more experience than others. So,
Got it. Well, thanks again, Owen. We've worked a couple times before on some probate deals. My escrow has said nothing but wonderful things about you, and
all
uh,
right.
you're one of the best they've worked with. So I appreciate it. If someone wants to get a hold of you, how do they reach you?
They can call the office. The firm name is Opelon, Opelon. So you can just go to opelon.com. You can call the office 760-278-1116. I'll chat with just about anybody. So if you call the office, you'll be able to talk to me. So you can reach out that way. And
Perfect.
yeah, hope to meet some of you
Great.
that are listening.
Great.
And also just right back at you, Brad. I really appreciated the times we worked together. You did a great job on the sales that we worked on. So I know we'll probably be working together in the future, and I look forward to that. Thank you.
Thank you for watching. If you have a property in probate that you feel you might need a hand with, please give me a ring. I'm Brad Green, Probate Solutions Group in Green Realty, 858-735-9405.